Welcome to Dorsey & Whitney's webinar on practical and ethical issues for lawyers serving on a nonprofit board of directors. I'd like to introduce Mackenzie McNaughton, a senior attorney in Dorsey's Healthcare Transactions Regulatory Group. Mackenzie?
Hi, thanks, John. Thanks everybody for joining us today. I am thrilled to introduce my co-presenters, Bill Jonason and Bonnie Pastben here as we talk today about ethics and serving on nonprofit boards, especially lawyers serving on nonprofit boards. Bonnie and Bill.
Thank you, Mackenzie. I wanted to add that Mackenzie is going to take the lead in this presentation because she's the real expert. She was, before Dorsey, was at Ernst & Young, and before that with the Internal Revenue Service, and at the IRS was focusing on tax-exempt organizations. So Bonnie and I are going to provide some color commentary, having been on a bunch of nonprofit boards over the years, and we'll kind of add some anecdotal tidbits here and there from our experience. Bonnie?
Thank you, Bill. I'm really pleased to be on this panel with the two of you, and I want to encourage folks when they're serving in these roles to make sure that they bring in expert outside counsel when needed. I've been using Mackenzie for a lot of our Alaska headquarter-based clients here at Dorsey, and just last week, one of my clients said Mackenzie was able to give the foundation the advice they've waited for years to get. So with that, Mackenzie, baton to you, and thank you.
Thank you both. And I can't, folks can look at the slides and look at the speaker bios at the very end, but I also can't emphasize enough that both Bonnie and Bill have incredibly deep knowledge in corporate governance. They're both experts in their field and serve as general counsel for a lot of for-profit companies. So there's a lot of knowledge on the panel today about corporate governance in general. And ethics in nonprofit space is so intertwined with nonprofit governance that this isn't going to be a typical ethics presentation, even though you get the credit, and that's great. So a couple of housekeeping things. We've got an hour today. We've got a lot of content, so we'll get going on the substantive comments soon. Info about the materials and attendance form and question Q&A stuff. We're not going to have time to take Q&A today. You can reach out to any of us independently. Our contact info is at the end of the slides, or we are also on the Dorsey website. You can get our phone number and email there too. So, and you can also submit questions on the chat. The three panelists won't be monitoring the chat, but my other colleagues here at Dorsey will, and they can take records of the questions if need be. So, okay, today we're going to talk about lawyers serving on nonprofit boards and ethical issues that come up. So as you can see here, we'll talk about the background, like sort of level set, duties of nonprofit directors in general, very similar to for-profit, but there are some differences in the nonprofit space, and steps that you can take individually if you are serving on a nonprofit board and you're a lawyer to protect yourself and the organization. Some ethics resources that are great across the board. And our last section is sort of a top 10 of best practices for nonprofit boards. And it incorporates all the tenets of the ethical and governance issues that we'll talk about today. We will not have time for questions, as I just said, so that's a bit of a false bullet there, so sorry for that. Okay, so the background to level set a bit, and Bill and Bonnie know this, this is their wheelhouse every day. Environment's changing. Some of this is a little bit old news from 2002. The Sarbanes-Oxley Act really beefed up governance issues across the board for-profits, and some of it applies to nonprofits as well. And here's a link to some of the Charities Review Council is a bit of a watchdog for other for the charitable space. There's several that sort of function in this space. But the Charities Review Council, if you link through there and through the smartgivers.org link, gives some really good governance issues. And they focus on rating organizations based on governance practices. So, okay. So you are a lawyer and you've been approached or you volunteered to serve on a board of directors. Good for you. It can be extremely rewarding. But today we're going to talk about a lot of ways that it can go sideways for you, both personally, professionally, and for the organization. So there's a lot of pitfalls. And what I find is a lot of small organizations or new organizations they're so enthused about the mission and they're trying to think about who should we ask to be a board member. Well, a lot of times they'll target young lawyers. Oftentimes it's younger folks starting a new nonprofit, and they're like, "Oh, my buddy's a lawyer. I'm going to ask he or she to serve on this board." That's great, but it doesn't mean that new lawyer is now the general counsel for this new organization. So we'll talk about some ways to sort of make sure you're wearing the right hat when you're acting as a director and keeping your lawyer hat and your board director hat on at the right times. There are times you can wear them at the same time, but most of the time you're going to be acting in one capacity or the other. So as a director of a nonprofit, the nonprofit space is all about transparency. If you're new to the nonprofit space, if you've never served as a director or you've never really gotten involved with a tax exempt nonprofit board before, your name and address are everywhere. It seems it's on the organization's annual Form 990 filing. It's required to be on there. If you're a director, your name and your address is on there. If you get any compensation whatsoever, it's going to be listed on there. So there's IRS reporting and disclosure. And a lot of folks look at the 990s. It's not just the IRS. I look at them all the time for my clients and for other organizations that they're doing business with, like how is this run? So it's a resource for the public, it's a resource for the media, it's a resource for other regulators like the state attorney general's office. In Minnesota, where I sit and Bill sits, there's an initial registration form for many organizations, and you also have to submit your Form 980 for them too. But if you're going to raise any sort of funds in Minnesota, I think it's over $25,000, you need to register with the state of Minnesota as well. And the Attorney General's office then says, okay, great, thanks, show us your 990s every year. Plus, tell us all your board of directors and their addresses. And then importantly, I wanted to mention, especially for this audience, there's often director disclosures that you need to make individually if you're employed by a law firm, or even if you're in-house at a corporation. Make sure you follow your employer's procedures before you volunteer, I guess in any capacity, but especially in a fiduciary capacity on the board of directors. Okay, so what do you need to do if you are now a director for this nonprofit? What does that mean? So these 2 points are really kind of crucial to understanding nonprofit governance, which is a little bit of a different animal than for-profit governance, because there's no shareholders. You, as a director, are an actual owner in a fiduciary capacity of these charitable assets. It's up to you to be responsible for these assets. And that's a little bit mind-blowing for some folks. It's like, well, it's just volunteer and they're charitable, right? No, you have the fiduciary responsibility by assuming your role as a director, even if you're not an officer, as a director under state statute, to sort of make sure that these assets are used prudently for charitable purposes and continue to be used for charitable purposes. And we'll talk about some of the blowback that can happen if directors don't make sure they're used for charitable purposes. So who cares about this? And what can happen if things go wrong? Well, it's usually from the state attorney general's office. Minnesota is a very active attorney general in the charitable space. California and New York will mention too some of their actions for making sure charitable assets are preserved and used for charitable purposes. So they have standing, the AG's office, to challenge any wrongdoing that they think might be happening in a nonprofit organization that's housed in their state or incorporated in their state, and they'll do so. And I'll reference a couple of recent decisions by the Minnesota Attorney General, and I'll reference the active action, but it's actually a state court action in New York for another nonprofit organization. Actually, I'll talk about them now. Now, I think it makes more sense to do that. So in New York, the state attorney general's office is very well funded, very, very, very active. National Rifle Association has been in the news. They are a 501c4 organization, so they're not a traditional C3 charitable organization. They're a social welfare organization. But the Attorney General's office said, hey, we think that you're overpaying your executives and you're misusing charitable assets. So last summer, the New York State Attorney General filed a lawsuit and said, all right, so we're either going to dissolve this organization, take the existing assets and redistribute them to charitable organizations, or we're going to replace all the governance, including the entire board. So that is still pending in New York State Court, a really interesting case for tax exempt folks. One other smaller scale organization is, if you look on the Minnesota, if you're in Minnesota and you are interested in this sort of stuff, you can go on the State Attorney General's website, and they will often have under their communications, they'll say, oh, there was a settlement with a charity. And the most recent one is from September 23rd, and it references a charity called A Place to Call Home. So it's a one-page summary, and it highlights a lot of things that we'll talk about today of how not to be a director for a nonprofit. The state AG's office filed 3 settlement agreements in Ramsey County District Court last month, requiring this organization's 3 directors, one in particular, to never serve on nonprofit boards again. So they're barred from ever serving as a nonprofit director. One director has to pay back $66,000 to the charity that she used for her personal benefit. She paid her mortgage, she bought a house. Can't do that. It's a breach of your fiduciary duty. And if she in particular violates this agreement, she has to pay an extra $60,000 in penalties to the Minnesota Attorney General's office. And this is just for a smallish charity. So you can get in big trouble if you don't do this right. And the other 2 directors got in trouble because the AG's office said, look, you guys authorized this. You didn't ask questions. You didn't say, hey, don't do that. So they all are in fairly big trouble. And for us lawyers, you know, if you work at a law firm or if you even work at a corporation, this is all public and your employer is going to find out. So it's embarrassing for your employer. It's embarrassing on, you know, their state bar association. Like none of it's great. So what can you do to sort of be a good board member? And it's kind of a big job, right? But as a board member, you are sort of at a high level. You're not day-to-day stuff. And us lawyers, that's kind of hard to wrap our heads around because we're fixers. We want to get in there and like, we see something's wrong, we kind of want to right the ship and we want to just know all the facts. You won't necessarily have that luxury as a director, which might drive you crazy. So, but you'll just have to accept it and get on board with it early on. So I want to go to the middle of the one. So the board selects, evaluates, and removes the CEO. And there's different terminology. You can use the CEO or the executive director is often used in the nonprofit space. That's the person that does run the day-to-day stuff. He or she will report to the board of directors. So the board is his or her boss, but the board they're not running the programs. They're talking about policy, they're approving high-level budgets. And then they hand everything off to the executive director and say, okay, do this, please. Run the programs, do that stuff. So that's the sort of thing that kind of you have to get comfortable with as a board member. And I know that I didn't specifically ping Bill or Bonnie on this question yet, but did you have any other issues that or I guess comments that you wanted to share in that regard of sort of thinking, this is high level and I need to just step back sometimes and it's hard in serving on a nonprofit board?
Maybe one comment I'd add here is that, you know, being a board member is not just showing up. You want to ask questions. You want to, as a lawyer, I think it's always appropriate to get a copy of the certificate of incorporation or articles of incorporation and the bylaws. And I've found in several situations, the bylaws were very outdated, had not been reviewed in a long time, and the board really wasn't following the bylaws. And so I've gotten involved in helping the organization revise and update their bylaws. So I think it's kind of a getting into the weeds. It is understanding how the organization is run and is it following its appropriate governing documents.
That's a great point. And as a new board member, you hope that you'll get sort of an onboarding package. And this is what I tell my clients often, like, do your board members a favor, give them your articles, your bylaws, your Form 1023 application, give them the kitchen sink. Give them your handbook if you've got one, give them your policies, let them see this, go through it, read it, ask questions if they need to. But yeah, there's some work, again, like Bill said, don't just show up. There's a lot of work to do as a director that you need to sort of educate yourself on the organization and their mission. And I will say, don't be afraid to say no. If this isn't going to be a good fit, if you don't get, if you're not fired up about their mission, sometimes board service looks good on your resume, but if you're going to be sort of a disinterested director and a passive director, that's not a great, that can really set you up for some, some missteps, especially in the nonprofit space. Okay, so what are we talking about here when we talk about fiduciary duties before we jump into this next section about personal liability? You, as a director, are serving as a fiduciary for this organization over the charitable assets of this organization. So that involves, just like your for-profit duties, duty of care, duty of loyalty, and duty of obedience. These are common law concepts, but oftentimes states will codify these in some way, shape, or form. Minnesota has codifications of the duty of care and duty of loyalty in the nonprofit chapter 317A. So this next section, we're going to look at ways for lawyers and other board members to fulfill your fiduciary duties to the organization while still protecting you and your individual interests and your professional reputation too. Okay. So as I referenced before, state attorney generals can be very excitable when it comes to misuse of charitable funds. And I did reference a couple of examples of when the state attorney general's office, and it happens way more often than you'd see in the news. It happens a lot where they'll reach out and be like, hey, this won't work. Either we're replacing the board or placing one particular director, or you guys need to fix this. So what can you do individually, new director, to sort of protect yourself and actually get the rest of the board or the organization talking about the things that we need to be talking about? Well, for good governance, and good is in air quotes, I guess, a nonprofit board especially should meet at least 3 times a year. Oftentimes you're volunteers and it's kind of hard to make space for that in a schedule, but a board really should meet at least 3 times a year to talk about things. I mean, you need one annual meeting just to elect officers oftentimes or re-elect directors, but to talk about substantive items and review the 990 and financial statements, if you have audited financial statements, you need to meet at least 3 times a year. I see most boards often meet at least quarterly, but it depends. So, and I recognize that for some small organizations, we talk about committees on this page, and committees can be a really efficient way to delegate responsibility that, the minutia that the full board doesn't care about, whether it's just a special project that's going on, or, capital issues, something like that, any number of things. You can use committees, but for smaller organizations or newer organizations, oftentimes it's just not, it doesn't make sense yet. They're not big enough to use a committee. So take that with a grain of salt, especially if you're in a small organization. Your annual budget's $100,000. You're probably not going to have multiple committees on your board. You just won't need it. And anything else I wanted to say that? Nope, that covers that slide. But again, I think that there's something on here. Bill said, we'll echo this throughout the presentation. Don't be passive, ask questions. That's, don't rubber stamp things, especially your 990 and other compliance related filings and the budget discussions. Don't rubber stamp that stuff. Really understand what's going on, how the revenue's coming in, expenses going out, how your programs are operating. Make sure as a board member you understand all those things. Okay, so other things directors can do. Oops, excuse me. Bonnie, I have a question for you on this one. We talk about conflict of interest policy for duty. Now we're into duty of loyalty issues. Conflict of interest loom large a lot of times, just being, having dual roles of, lawyers, advisor, lawyers, board member can be a conflict of interest. But we also talk about financial and fiduciary conflicts of interest. And I wanted to level set that a little bit before I turn it over to you, Bonnie. If you haven't had to think through conflict of interest in this space before, a financial conflict of interest is a director that has a competing conflict of interest. I mean, there's something, it's got a common investment with this organization, or there's just something, or their sibling is getting paid by the organization and they can't make a decision, they shouldn't be involved in comp decisions for their sibling, et cetera. That sort of, just money stuff. But the fiduciary conflict of interest happens more often in the nonprofit space than you would think, where you've got a divided loyalty between this organization and maybe you serve on another board that has a similar mission and they're trying to develop a similar program or just something. You've got divided loyalties in whatever space. So that's what we mean by a financial conflict and a fiduciary conflict of interest. And your conflict of interest policy, you all should have one. All organizations should have one. It's helpful if it addresses both specifically. So Bonnie, I'll turn it over to you because I know you have some thoughts on this issue too.
Thanks, Mackenzie. A couple different directions with thoughts. One is, when I give training on conflicts of interest, I always just focus on early and often disclosure ahead of the meeting. If you know an agenda item may affect you or your family or your organization, let the chair know. If there's a counsel for the organization, let them know. So if it's thorny, people can work through those issues rather than trying to deal with it in real time in a meeting. Secondarily, a little bit tangential, but just make sure when issues are coming up, if you need to have an attorney-client privilege conversation around those, consider if the meeting should go into an executive session, consider who needs to be in the room or leave the room. Here in Alaska, we have a very narrow control group, attorney-client definition, and particularly if you're an in-house counsel, preserving the privilege is even more complicated. So don't forget those issues when you go into the room as a board member, and try and help the chair make sure if you need to be in executive session, go in executive session, who should stay or go, and what happens with privilege. So again, encourage folks to think about those before you're in the meeting if you can, so that people aren't scrambling in the meeting. Thanks, Mackenzie.
Sure. And I actually have one question generally for the both of you. That's a surprise question, but it made me think of this. So we talked about how the executive director or CEO is an employee of the organization and reports to the board. I find often that, oftentimes they're not, and I personally don't think they should be a voting member of the board. There's no hard and fast rule often that says that. And especially for a really involved founder that's the executive director, they really want to be, they want to wear all the hats, right? Sometimes it's good board policy, and I don't know how either of you feel about this, if you want to talk about it a little bit, having the executive director sit in on board meetings, if that's a commonplace thing, or if there are times where it's like, okay, this is just, and this goes a little bit to what you're talking about with the executive session, Bonnie. What you think about that, especially if the executive director is like a ex officio non-voting board member?
Sure. So typically, like I sit on the Girl Scouts of Alaska board, and our CEO is fantastic and is in all the meetings except for example, in her annual review, for example. Then we would have her in for part of it, presentation, and then she'd be excused and we go through it. So Bill, you may have other thoughts around this.
My experience is similar, that generally the CEO and or executive director, it might be the same title, different titles, but they're, in my experience, they do usually sit in on the board meetings. They participate in the board meetings, often with the chair. They're helping to lead the board meetings. But having said that, usually at the end of the board meeting, and usually every board meeting, there's an executive session of just the board where the CEO / executive director will step out. And that way the board members have an opportunity to ask questions or make comments about the CEO / executive director without him or her there. And so if there's any questions, comments, concerns, it can be addressed in that manner.
Those are great practical points, especially for, again, like I said, I see excited founders that are, they wear way too many hats sometimes. And it can be good just for board members to have that knowledge of like, okay, there are times when it's not appropriate for you to be here. And part of your job as being a board member is to draw those boundaries to protect the organization and yourself, of course, as a board member. But yeah,
and
it's
maybe
just,
one other piece of color, maybe a variation of that, depending on how big the organization is, it could be that other staff members, officers, vice presidents, for example, or directors of various units of the organization are at the board meeting as well. And sometimes there will be a kind of a two-step executive session where the staff, other than the executive director or CEO, they'll all step out at the end, and we'll have some discussion, if appropriate, with the CEO/executive director, sometimes regarding the staff and how things are going with the staff. And then thereafter, the executive director/CEO steps out, and then further discussion, if necessary and appropriate, regarding the executive director/CEO.
And yes, and Bill, for sure, that totally ties into, for example, our Alaska attorney-client privilege control group. You would break privilege if non-control group staff are in that discussion.
yeah, great points. And those are really good practical points. And those aren't the sort of things that, yeah, they're handbooks and stuff, but it's hard to kind of know that as if you've never served as a director before, like your head's kind of spinning, and just keeping all this corporate governance stuff straight is impractical sometimes. So that is a great reminder across the board. Thank you both. This next slide and the slide after, we'll talk about ERISA liability. I try not to talk about ERISA ever because it just makes my head hurt, but I'm not a benefits lawyer. But this is really for bigger organizations with employees. You've got benefit plans. In the interest of time, I'm going to skip over this one and the following one. So yes, if you do have plans subject to ERISA, we'll talk about directors and officers insurance, D&O insurance throughout this also. It's worth, if you have these plans, purchase an ERISA rider. Okay, this is, if it can be a fun or a really anxiety-inducing slide when we talk about unreasonable compensation, excess benefits, section 4958 of the Internal Revenue Code. This is when the IRS cares about how much you're paying your people, how much you're paying your executives, how much you're paying just staff sometimes, if related folks are getting unreasonable amounts, so misuse of charitable funds. So this is exactly what state attorney generals care about too. So you have sort of a two-pronged attack sometimes if there's a misstep in this area. And the Minnesota Attorney General case I referenced, where the woman had to pay back $66,000 of the charity's funds that she used to pay her mortgage, she had to pay that back. She may also have penalties, and her fellow directors may also have penalties under section 4958. And that section of the code is a self-reporting requirement. You want to get in front of it before the service finds out, because they're going to be really upset with you if they have to be the ones who are like, oh, yeah, you really messed this up, didn't you? You want to ask for forgiveness. And it's also publicly embarrassing. Not only is the Attorney General involved oftentimes in these scenarios, but it's on your 990, a Schedule L, 4958 excess benefit transactions. You can look and see. Your favorite charities have ever had these. You can go through their 990s and look at their Schedule Ls. But yeah, and we'll have some more discussion on this in the best practices session too. But yeah, this is one area where if you approve an excess benefit transaction as a director, even if it's not for you, you may be tagged because you said yes to it. You may be tagged with excise taxes. That stinks. Like, you don't want to have to write a check because of something you did or didn't do as a director of a nonprofit organization, especially if you're a volunteer. And this is something that the organization can't indemnify you against, and director and officer insurance excludes this type of violation as well. Okay, so what can you do? This is right from the section 4958 regs, this concept of a rebuttable presumption of reasonableness. There's a lot of literature written about it, but it's distilled really to these three concepts. You can't be conflicted and approve compensation. You need to look and see, like, what are peer organizations doing, or are you big enough that it makes sense to do a compensation study? And as a board, when you're just making these decisions, you need to write it down. Same time, don't go back in time and do it. When you're actually voting, make sure you've got corporate minutes or some other memo to file, documentation saying, this is how we got to this decision. And I know, Bill, you have a lot of experience in this area in different flavors. So was there anything you wanted to add?
Yeah, a couple of things that I've done or been involved with on boards, and this will depend on the size of the board and the size of the budget. If it's a big organization, you can have a compensation study done. And I've been on boards where that has happened. And some of that is more from the perspective of the organization wants to keep the CEO happy and keep the CEO there. And with the big organizations and the well-known CEOs, they can be a flight risk. And so you want to make sure the compensation is competitive on the one hand, that it's as high as it should be to keep the person there, but you don't want it so high that it's unreasonable. And so if you're not large enough to support a study, what I have done is I've done my own looking around at Form 990s, other comparable organizations. So some of the boards I've been on, when I've been chair or part of the compensation committee, I've actually gone and picked out 10 organizations that I thought were comparable in terms of size or location or mission, et cetera, or a combination of all of that, and looked at the 990s and checked the compensation for those CEOs or executive directors. Now, the one downside of that or disadvantage or practical aspect is the 990s you're going to get are not real-time 990s, are going to be dated by a year or two, but at least that can help you set some parameters of what might be reasonable and appropriate.
Yeah, that's a good point, Bill. And also for folks who haven't had to think about comp issues for nonprofits before, nonprofits are, you can't do a lot of incentive compensation for them. So compensation can be a really big deal. And it's been in recent legislation too, where you're like, well, these state schools with football coaches making millions and millions of dollars, like how does their compensation get set? There's really interesting IRS rulings about that, which seem to fly in the face of other executive comp in the nonprofit space. But that aside, Congress is also interested in executive compensation, and Section 4960 is a new addition to the code that imposes an excise tax on amounts over $1 million paid as compensation annually to folks in the nonprofit space. So, that sort of stuff, if you've got an organization paying Section 4960 excise taxes, if they're paying, well, and for non-medical, the medical services like docs and veterinarians are excluded from that pool. But yeah, that executive comp gets a lot of media attention too. So in addition to just IRS reporting it, attention. Okay, so here's another scary slide. We talk about personal liability as a nonprofit director. Bonnie's nodding because she's heard horror stories, so have I. Before I was at the IRS, I was in private practice in the DC area, and I had an acquaintance call me, panicked. I was doing nonprofit governance work then too, but she said, I'm on this board and, that I just got a notice that I'm liable for employment taxes. They didn't pay it. And I was like, that sounds terrible. And then I went to the IRS and I was like, I can't help you. But yeah, this really happens. The IRS does go after employment taxes that aren't paid from a nonprofit. So this is just for organizations with employees. And I will say, don't think that you can get around this by calling all employees or people who do work for an organization independent contractors, because then you get into worker classification issues. Don't do it. Just call, if they're employees, withhold their employment payments or employment tax payments. My word of wisdom to most clients is, I don't care how small you are, if you're going to have an employee, hire a payroll provider, have them take care of it. And as a board member, make sure that payroll provider is actually making the payments. You might want to do a little bit of extra due diligence. But yeah, Bonnie, I know you have experience with this issue specific to nonprofits too. It's
Great. Yeah, and it's sad, especially if it's someone who doesn't have a high income, it's kind of the no good deed goes unpunished, where somebody asks as a favor for them to serve on a board. They don't really dig in and figure out if things are going correctly or not. And then personally having to pay payroll taxes is just tragic. So again, due diligence and understand the organization and if they're on the up and up and doing what they need to do.
Yeah, agree. And the IRS uses the term responsible party. So if you're the treasurer of the organization, you're a responsible party. And oftentimes just being a director, you can be a responsible party also. So, okay, so now here's sort of a traditional ethics issue that we think about as lawyers serving in dual roles. So your dual role is a lawyer, if, you know, in your professional life, and you're serving as this volunteer, oftentimes volunteer. You can get paid for service on a board. It's not as common as a volunteer role, but these dual roles. So what comes up? And Bill and Bonnie have both alluded to this a little bit in the beginning, but Bill in his, you know, real life is a well-known mergers and acquisitions attorney. Bonnie is a well-known corporate governance expert. So do you have any extra thoughts about serving in this dual role of like how you keep your hats on and think about your role as a nonprofit director and a lawyer?
Well, a couple of things. One is I'm always careful about only offering advice as to those things I know something about. And the other part, depending on what your, you know, law firm rules might be or in-house lawyer rules might be, you got to make sure you do the appropriate things and to make sure that you personally are protected relative to any advice you might be offering. And so here at Dorsey, for example, you know, generally, if we're going to be, we, Dorsey, are going to be offering advice to a nonprofit, we would open a separate file for that. But as a practical matter, things will come up that don't rise to that level. I mentioned early on reviewing bylaws and helping with that. And I might jump through the hoops to open the file for the bylaw review. If it's not a fulsome review and it's more just off the cuff, I might not jump through those hoops. So I think it's a judgment call, and in terms of how big or little is this advice you're offering and what are the risks.
So if I could just chime in quickly on that point to make sure that you've looked at the risks. At Dorsey, we're also required to get copies of any D&O policies that your nonprofit has. Recommend that you do that regardless and understand what sort of deductibles the nonprofit has and do they have the assets to pay those if there's a claim. And as Bill said, you know, we do open different matter numbers. So for example, for my Girl Scout service, I have one matter number for when I'm serving in the board member capacity as a director, and then one for when I'm doing the legal work. And I actually track my time that way, just for tracking purposes, because obviously we're not getting paid for it. It's all volunteer work. But I think it helps me mentally keep my hat straight on which hat am I wearing and why. And again, can't echo enough Bill's comment. Be careful about what advice you're giving, and if you're the right person to get it, and if not, you know, pull in a specialist for that area and recommend that competent counsel get the right advice that the client needs on the specialty knowledge that I certainly don't have on the tax side, for example. Thanks.
Yeah, and I find employment law is also always looming large for any organization, especially nonprofits with employees. So I'm not an employment law attorney, and I'm good friends with our whole labor and employment group because it comes up all the time. So if you're not a labor and employment attorney and you're serving on a nonprofit board, you know, that's the sort of stuff that can sort of get you into trouble if they start asking you legal questions about that. Okay, so is there a statutory protection? Yes, for some things, if you're a volunteer director, Minnesota has statutory protections for certain liabilities that might arise through service as a volunteer director, but this goes away if you're compensated in any way for your board service. So most things I find that can get you into trouble aren't covered by this. So there's a pretty broad exceptions here, and there's not a ton of case law in this area. But just something to be thoughtful about. If you are in an organization that's talking about compensating directors, this is something that you should think about too, that you would lose this protection many times in most states. So that statutory protection does not apply to the organization as a whole. You know, they can still get sued just like any entity could for, you know, any legal action. And you can still get sued individually as a volunteer through your own individual actions, tortious actions. So, and unfortunately, you still have to, represent yourself or pay outside counsel to represent yourself in that capacity. The last big thing I wanted to talk about in this section is indemnification as a director. And I'll go over this quickly. You can read the slide, but a nonprofit organization can proactively indemnify its directors in its articles of incorporation. And that's something, if you're looking at their articles, that's good language to have in there. We put that in there as part of our template typically. The only trade-off is that you need to be in an organization that could afford to indemnify you if you get sued. So if you're in a small organization, it may not make any difference if that language is in there and their budget is, $50,000 a year. So something to be thoughtful about. Lastly, D&O insurance. It's come up a lot. Make sure your organization has it. If it doesn't, make sure it gets it. And there's no magic firm or anything that offers this. You can shop around, and whatever insurance broker that offers it will you can get quotes. And Bonnie, I don't know if you had anything else to say about D&O insurance. We talked about
I think already covered that. Thanks.
Okay, perfect. All right, so here are some ethical resources that I find useful in my practice. Bonnie and Bill have both found useful in their just nonprofit practices. And in Minnesota, again, they have a very active Attorney General's office. And if you click through that link or go to their site, there's actually, it talks about fiduciary duties, duty of loyalty, duty of care, goes through many of the concepts that we talked about today. So the AG is on top of it as well. And Bonnie, do you want to talk about the last one? Because I hadn't seen that one before you brought it up, but it's phenomenal.
Sure. So here's my little show and tell. So this is a book that I spent the weekend with. The American Bar Association Business Law section has gone to the trouble with the Nonprofit Organizations Committee to do a 350-page book called The Guidebook for Directors of Nonprofit Corporations. And happily, we had this in our Dorsey library. And I just want to say, it's fantastic and has tons of questions by topic and checklists for organizations. And so highly recommend this resource or any analogous resources that help you get your head around what questions should you be asking and what due diligence should you be doing, so you never have to worry deeply about how much D&O coverage your organization has, I hope.
I know nobody's ever going to serve on a board. We've talked them out of all of it, but no, you should. It's wonderful. Okay, so this last section is sort of a top 10, and it's going to incorporate many of the things that we've talked about. There's going to be some redundancies in here, but redundancies are great sometimes. And the top 10 list came from my colleague Claire Top, which many of you on the call probably have worked with or know her. She's phenomenal, and she is sort of a pillar in the nonprofit community, especially in governance issues. And she really. She teaches at the University of Minnesota Law School. Like she's put together a great comprehensive list. So here it is. The first thing is, this is what you need to do as a director. So, and helping your board sort of incorporate these into board practices. A good board should have, what I find helpful is having a matrix of skills, of board skills. A lot of times in New York, we'll be like, oh, we need an accountant and we need an attorney, and then everything else just sort of falls by the wayside. But right now, I find a lot of discussion in this area about diversity and inclusion, and just what do you know about the mission? Like, can you help this organization get stuff done and point them in the right direction to effectively implement their programming? We have here, I have a couple of clients that are in the Native American space, and they need the insight and knowledge of Native American peoples on their board. So that's something that they really think hard and they're very thoughtful about. And sometimes somebody with savvy fundraising skills is a really good add to your board. So having that matrix based on mission and sort of execution of the organization is important here. So yeah, and we talk about compensation. Again, that's another issue for another day. Most folks, you can get a stipend also. but the board can, or the organization can cover reasonable costs, reasonable expenses. If you go to board meetings, someday we might do that again, but I don't know. But yeah, that's something you can do as long as it's reasonable. Don't fly first class. Thank you. But yeah. Oh, this is a good thing we haven't talked about. When you're wearing too many hats, try not to be the president and the treasurer. Sometimes there'll be a state statute that says you can't do that, but not always. So for best practices purposes, you shouldn't be the chair of the board and write all the checks. Sometimes term limits are helpful in this area too, just to keep your board from going stale, get some new blood in there. And sometimes it's like, well, that's a lot of work. Yeah, it is. But sometimes it's really critical to the mission and keeping it fresh and alive, and just being a very good, alert board. So, okay, number 2 is define your roles as board members, committee members, and senior management, which that can be your executive director, et cetera, or other, management roles, employee type roles. And what I see in this area, oftentimes we'll write job descriptions for board members, or a job description certainly for the executive director, because the board has to give annual reviews. But this is good to sort of, as an onboarding practice too. It does your board members a favor if you say, here's what we expect from you. So I don't know, Bill or Bonnie, if you've had any experience of getting that when you joined a board, like, oh, this is what you want me to do? Okay, great. That's fantastic.
Yeah, I had to sign my conflict of interest and job description last night for the Girl Scouts. So
it's very fresh, very fresh. Okay. Yeah. And one thing I will say too, this last bullet reminded me, the board and the executive director, it behooves you, even if you don't like their personality, it behooves you to be at least on good speaking terms with the executive director. Once that relationship becomes fractious with any board member and the executive director, it becomes really hard to kind of govern around that sometimes. And I see a lot of things that started small and just ended up blowing up just because of personality conflicts in that area. So just something to be thoughtful.
Mackenzie, is it okay if I chime in here?
Sure.
Okay,
That's where all the good stories come from.
Yeah, so speak with one voice, echoing back to duty of loyalty, and this can also be an issue in the for-profit space, that as board members, it's important that folks express their dissent and deliberate in the boardroom and hash things out there. And if you really strongly disagree, make sure you put your dissent in the official minutes and vote against a measure. But it's super unprofessional and negative to take those ventings out into the space, Facebook or otherwise, very damaging to a nonprofit's brand and reputation if board members are out trash talking what's happening in the boardroom. That's not helpful. And if something's significant enough of an issue, try again ahead of the meeting if possible to raise if there are legal concerns, ethical concerns with the chair, the CEO, if there's board counsel. If it's bad enough, seek your own counsel. You may need to resign from the board.
Mm-hmm. Yeah, I just had another Dorsey colleague telling me on a volunteer organization that she serves on, that exact scenario happened where it was like, they were trash talking outside of the boardroom, and the collective board said, what are we going to do here? And they ended up removing the director. So it was really, really difficult and not something that you want to have to navigate. So this next 2 slides talk about dashboards, and that can be helpful to a board, but I'm not going to spend a lot of time on these, but there are some helpful links here if anybody is interested in using it in their own organizations or just curious about how a dashboard and these metrics work if you're a data analytics type of person. I'm not, but okay. Third item on our list is internal controls. And my experience at Ernst & Young, I helped a lot with the audit teams and looked at internal controls for nonprofit organizations. And I think that if you don't have any and you're an organization of any size, you might need to think about, like, maybe we should start at least, writing down policies in certain areas, whether it's compensation or, just having volunteer, if you've got sort of complicated volunteer activities, it might be worth thinking about creating a volunteer policy, IP policies, if you've got folks creating content for you that you share, that sort of thing could be internal controls. But I know that Bill also has thoughts or has experience with internal controls that sometimes it's significant transactions, but not always. So Bill, did you have any thoughts on this issue?
Yeah, one thing that you might want to think about, depending on the size of your organization, is whether there are certain dollar limits for expenditures that the CEO has to bring to the board. And I've been involved in a couple of organizations where we've done that, set a certain threshold that's over that amount, it has to come to the board. The other aspect of that is kind of check signing authority, and over a certain amount, it might require 2 signatures instead of 1. Similarly, kind of working through the appropriate independence as to approvals, like for example, the personal travel expenses or other expenses, business expenses of the CEO. How do those get approved? And this can also be part of the conversation you have with your auditors on an annual basis when they present the financial statements. You can go into executive session and have a discussion with your auditors of the organization, what they see, what they think, and do they have suggestions or recommendations in terms of appropriate internal controls?
Yeah, and I will, just one point to follow on that. For a smaller organization, at least in Minnesota, if you're under $750,000 in annual revenue, you don't need to do audited financial statements. I think it's a really good idea to do them, even if it's just a small, even if you don't have much activity. Audited financials are fantastic. And what they do is they're another way for an external person to come in. Usually it's an accounting firm that has an audit function. They'll come in, they'll look at your controls, they'll look at your books, they'll look at your general ledger, and they'll categorize your assets for you, and they'll present them on your financial statements. And then you can present that publicly to folks that say, okay, this looks like a fiscally healthy organization. They've got X in revenues, they've got Y in expenses, they've got this much in restricted funds. And it's really a useful tool for donors. Big donors will sometimes ask for audited financials, even if you are right now a smaller organization. So it's a good practice to get into, and your board should absolutely look at and read your audited financial statements and the footnotes. The good stuff is always in the footnotes. And I've seen organizations and boards of directors get into trouble when it's like, you should have seen this. Had you been paying attention, you should have seen this 5 years ago. Now you're in complete financial dire straits. And this might have been prevented had you all sort of rung the bell earlier. So same with your 990 annually. You should have, somebody's going to sign off on it. As a board member, it's really dry reading, but you should at least take a look at it and say, this looks weird. What is this? If you have any questions. So Bonnie, did you have any other?
Yeah, just another due diligence item for the board. Obviously, if you're not getting a clean audit letter on those audited financials, huge red flag. You better be reading at least the cover sheet and understanding if you've flunked or passed on internal controls.
Yeah, and that's a tricky dance for the auditors. I've been on that side because they get paid. Like they don't want to lose their audit clients, right? But they also, it's their job to raise these issues. So yes, if you don't get a clean audit letter, that means they've really thought long and hard, because it takes a lot for an auditor to put that in writing and say, hey, you might need to take a real close look at those things. Okay, so number 4, I'm not going to spend a ton of time on this, but self-evaluations can be great for the board. And you also, as the collective board, you're going to do annual evaluations for your executive director if you have one. So that's just some thoughts about that one. And the next one, number 5, is adopting a whistleblower policy. We do this for most of our new clients. We give them a template whistleblower policy. And I feel like it's just laying good groundwork, because stuff happens. Like, people aren't perfect and sometimes need to ring the bell, audit or otherwise. But I know, Bonnie, you've had some experience in this too with your for-profit clients as well. That's applicable to the nonprofit space.
So the guidance that I always really emphasize is make sure that your whistleblower hotline goes to multiple recipients. You know, if it's an email, like a pound email address, have that go simultaneously to multiple people, so that if it's the person who's the subject of the complaint, that they can't sit on that, and that you know, if something's complained about, that more than one person knows about it as soon as possible. And also, it's a good practice to have someone paying attention. Are there trends, repeated complaints by nature or subject or person, and, you know, reporting that up to, if, you know, you have an audit committee or even the full board. That's another best practice to consider, so that folks are really aware, you know, sooner rather than later, if there's a problem. Should there be an internal investigation? Should you retain an outside entity to do that investigation? And you know, have that investigator hired by an attorney if you want that to be potentially privileged. And one thought that just occurred too: remember, your independent auditor is not within the privileged bubble.
That's a good point. That's a good point. So speaking of audit committee, it's come up a few times. What is it? It's supposed to be an independent board members to oversee your financial reporting, audited financials, certain risk assessments, you know, financial risk, and other management practices. And this is fairly self-explanatory. And for a small organization, you may not need an audit committee, you know, right out of the gate. You know, this is something down the road as your organization grows, or certainly most big organizations, and by big, I mean like over $1 million, will have an audit committee. So you don't want the president and treasurer to sit on the audit committee. Usually you want independence. So it's hard to sometimes find qualified folks to sit on an audit committee, because, you know, oftentimes your financial person might be the treasurer too. So that's where your board matrix will help, you know, saying this person has the skill set or familiarity or is willing to get up to speed on this area. So number 7, this is related. The board should oversee finances, manage and spend organizations' funds appropriately. The board should know, at least at a very high level, what the annual funds are, how annually the funds are being allocated and spent across your programs, or however you do it, whether you're grant making or actual doing stuff. So, and oftentimes, Bill, you probably have some input on this too. If the executive director says 6 months down the road, like, oh shoot, we need to reallocate from this bucket to this bucket, oftentimes there will be a mechanism, sometimes in the bylaws, but sometimes just in internal policies of, if it's over X amount of dollars, you need to have board approval again to sort of shift money around. We're almost to the finish line, so thanks everybody. So this is just nonprofit 101. You have to be transparent. Programs, governance, and finances. Tell your story on the 990. That's your best free PR doc. I mean, it's not free if you have a paid preparer, but still, that's your chance to sort of sell yourself, tell your story. Your donors read it, the public reads it, the media reads it. You have to make your 990 publicly available for folks who ask. It's now on the IRS website. You can usually go and find the most recently filed 990s, both on the irs.gov website. They're taking it over from GuideStar, which used to be the exclusive provider, but now they're transitioning everything back over to the IRS. Hang on to your 1023s. People can and will ask for them. And the IRS is, in the next year or two, going to make them publicly available on their website, just like the 990s are. So just a pro tip. Don't just think your 1023 is a rubber stamp document, even if you're filing an EZ, which I don't like, a 1023 EZ. Yeah, hang on to them as part of your permanent corporate records, and people can and sometimes do ask for them. All right, number 9, you have these great policies, so follow them. And Bill mentioned this earlier, you know, an organization had bylaws, but they weren't following them. Your bylaws are your fundamental corporate governance document. These are the rules we're going to follow. And they were like, yeah, just kidding, we're not going to. So helping them make sure they're usable, workable documents. You can do that as a lawyer if that's your bailiwick. But yeah, that's all I had. Bill, Bonnie, I think we've got, oh, we're right at the top of the hour, but any closing comments?
Oh, thank you, Mackenzie. Good job.
All right,
Bonnie.
yeah, thank you both.
Thank you.
All. And thank you, audience, for sticking with us. We appreciate it. So here's some more housekeeping stuff. And feel free to reach out to any of us if you have any follow-up questions. Thanks again.